8 wheelers, my lord.
Yeah.
3 appeal items that were last listed on 1st of October because of there was no change in the bench. Could have listed, my lord. May come on 3rd, my lord, for admission. Third.
May please, Your Worship. Worship, I beg to mention item number 29 in supplementary list of Matter may come up on Wednesday, Lordship. In this case, we have filed implement petition. That was not come today. Matter may fix along with that.
What you have filed?
In Lordship,
You have filed
implement petition. We are not.
improvement petition for that. The improvement petition is already there.
No. This I is for stay vacating.
What?
Stay vacating.
Okay. We'll deal with it. You filed that application again.
We have already filed, but that matter has not come today.
In the due course. We'll see.
May I please the Lordship? I beg to mention item number 8, Lordship. I want to reply affidavit in opposition, Lordship. 2 weeks time may be allowed, Lordship.
Application for stay of the operation.
Yes, Lordship. I want to file affidavit in reply, Lordship.
Let the number comes.
Lordship, may I please, Lordship? I beg to mention item number 9, my lord. 9, my lord, and kindly matter we adjourn for a week, my lord.
You are for the
Petitioner, my lord.
letter. The number comes. This is the only for the delay confirmation. We'll see whether notices to be issued or not.
May I please, Your Lordship? Lordship, I beg to mention item number 12 of today's list, Lordship.
Yeah.
In this matter, Lordship, Senior Advocate Mr. P.K. Goswami is appearing. So, Your Lordship may not like to take up.
Put up before another bench.
Apply.
Yeah.
Any other request? Daily list for orders item 1.
Yes. Last time.
Yes, my lord. The
Indicates that
the department has, my lord, issued an office memo in the I give the copy. Appropriate steps are being taken, my lord. Look, my lord, এটা করতে হবে।
Whether it is functional or not.
And my lord, as of today, it's not functional, but we are taking the steps to make it functional, my lord. There are some technical issues also in getting the web. It's a web portal, my lord. We need some technical support also.
So
A little bit of work is left.
remember
also.
enough time on the last occasion and promised us that that would be in operation from 21st of November. Now again, that is
But we are not averse or we are not trying to resist the operation, my lord. It's only the technical delay which is taking place, my lord.
technical.
Unless we have everything in place,
You don't have the technical end.
we have, my lord,
Then-
we have a sample ready, but some needs to be made up, it is to be a public domain, my lord. There are some things which.
Okay, give us the last date or next date. We'll call who is the person in charge for that. This is the last one.
Towards the end of December, my lord, we'll try to have it.
Too much.
Add the
The
petitions.
third of 1.5 month time was granted earlier. Almost 2 months have been granted and still you are seeking for 2 months more.
No, a month.
Month, what do you mean by
It's
month?
end of November, my lord. I'm asking for
Sir,
December.
ultimately, it's for the benefit of the, and
It is, my lord. It is not that we are,
mandatorily required, it's not that, you're obliging anybody.
no, we are not obliging anybody, my lord. We're
Then-
trying to make it function.
This is not acceptable. Make it, whatever it may be, last date, 15th of December, you make it operational, whatever the technical or whatever support you want, you take it. Okay, pursuant to the order passed by this court on 3rd of October 2024. Learned counsel for the state has produced a office memorandum issued by the Department of School Education, wherein certain directions have been given to the concern for making the web portal operational. Full stop. It is admitted by the concept of the state that till date, the web portal is not in operation. Full stop. It is to be noticed that the state is seeking time from last several months for making the said web portal operational and operational. Earlier, it is stated that on account of operation of model code of conduct, the requisite steps couldn't be taken. Now, it is stated that the it needs some tech, for the operation of the web portal, some technical support is required, and for that, some more time is more time be given. It's stop. Taking into consideration that enough time has been granted to the state, we are not in support of giving further time. However, in the interest of justice, last opportunity is granted up to 15th of December 2024 to make the web portal operational. Full stop. We make it clear that if by the next date of hearing, the web portal, the state is not able to operationalize the web portal, will be forced to call upon the authority who is responsible for the same. This on 15th of December 2024. 16th. 16th of December 2024.
Obliged.
Item number 2.
Make the lordship. All right, we can move. My lord, for my convenience, I have made a short note, my lord.
Yes,
This is,
respondent number 1
yes, my lord.
is served. Respondent number is already served.
My lord.
You are appealing for,
Respondent number 1, Lordship CGC Limited.
you are appealing for respondent number 1,
Lordship.
national, what is that? Mission.
This is-
You are appealing for this national commission.
Lordship.
Okay. As per the office report, the notice upon the respondent number 1 has been duly served. The other respondents have also been served earlier. Stop. Now, what do you want?
I want
This,
this, my lord,
this,
be heard.
repetition for admission. When?
Lordship in the month of January, Lordship.
In the month of January.
Item 3.
May I please, your lord? There is a delay of 230 days.
Why? Why?
It came to knowledge after later, my lord.
Came to knowledge your.
And within a
not
10
there.
days, within 10 days from the knowledge, I have filed the appeal, my lord.
Your advocate was not there.
Advocate was there, but there was a group of petitioners, so I could not get the information, my lord.
Registered AD returnable 6 weeks. Yes.
Oblige, my lord.
Item 4,
Issue notice.
May,
Registered AD
I'm deeply obliged.
returnable 6 weeks.
item 5,
5, 6 and 7 similar, my lord. There is a delay of 530.
23 days.
But I'm paying for similar order, my lord.
Yeah,
I'm paying for similar order.
with similar order.
Page, my lord, 482,
Page
last, starts from page 482, man.
482.
Yes. In the appeal.
What is the similar order?
Similar, that is it, page 482.
Similar order in what?
Similar order, your lordship has directed them to consider the old pension scheme as per the government's own resolution. They've taken a policy decision to regularize, to provide old benefit of old pension scheme. Series of cases your lordship has disposed of.
This was regarding the old pension, the
Old-
applicability of the old pension scheme or the new pension scheme or the old, the Assam pension rules as it stood then, my lord. So there were two batches, One, we said that we will take a, we try to consider the cases. Perhaps that is the order they are trying to put.
Yes, same order. Resolution at page 472. 482, man.
There is no paging in it.
Horrible.
number
All operation like.
It's a simple direction for continuation of their activity.
But what happened when the other people had approached the honorable court, my lord, in a read appeal, they said silent. When this order comes, now they approach them. They did not approach this court, my lord, when with the other people, my lord, in the filing of the appeal. Therefore, the 560 days.
This to be ordered by.
Otherwise, my lord, otherwise we can do it. Otherwise, similarly situated if they are OBB teachers.
The matter comes upon for consideration of them. I remember. So, it's a thing of auto communication. The IA members, so, with the prayer to condone the delay in filing the connected date appeal, the delay of 523 and 496 days in filing the connected writ appeals. Stop. And it once after the petitioner, applicant has submitted that the learned single judge has decided a bunch of petition by a common order against which some of the agreed with the same, some of the similarly situated employees who the appellants have approached this court by way of filing a writ appeal, by way of filing writ appeal number 198 of the 2023. And the said writ appeal came to be decided by this court wide disposed of by this court wide order dated 26/7/2024, whereby it is observed that in view of the subsequent development that the state government has decided to consider the demand of the employees who were though appointed after 2005, wherein the recruitment process of the concerned posts concerned post was started prior to January 2005. It would be appropriate to dispose of the appeals awaiting the decision of the state government on this issue. Full stop. The division bench has also made it clear that if the appellants fail to get a favorable decision from the state government, they are free to approach this court again by filing fresh writ appeals. The council has submitted that the case of the appellants is similar to the appellants who have preferred writ appeal number 88/2023. Or what?
Yes, sir.
2023. Full stop. Learned council appearing for the state is not in position to 188/2023, 88. Learned council for the state is not in position to dispute the said factual position, full stop, taking into consideration the same. We are of the view that delay of 523 and 496 days in filing the connected writ appeals is liable to be condoned. Hence, the IA number so and so are allowed, and the delay in filing the connected writ appeals are condoned. Stop. Since the writ appeals, connected writ appeals are to be decided in terms of the order dated 27/7/2024 passed in writ appeal number 188 of 2023. We 23, without waiting for the formal registration of the connected writ appeals, we deem it appropriate to dispose of the connected writ appeals in terms of the order dated 26/7/2024 passed in writ appeal number 188/2023.
The time frame would start from the day they give the certified copy, my lord.
However, it is made
It
clear
was
that
July then.
the time period of 6 months, that is 6 months,
6 months.
the time period of 6 months granted by this court by the order dated 27/7/2024 in writ appeal number 88/2023 shall start in the case of the appellants from the date of production of certified copy of the chart.
Obliged.
Writ appeal,
26/7.
writ appeal 188.
26.
Writ appeal 188.
Yes.
Obliged.
Number 5 and 6.
5, 6, 7.
Item number 8,
Please proceed. Excuse my lord. Your lord, yours,
Just a minute.
order
Just a
29,
minute.
2004.
Just a minute. Wait for me. Yes.
Lordship, may I please the Lordship. Lordship, the process of filing of reply is going on. Kindly.
Therefore,
I am for respondent number 7, 8, and 9, Lordship.
what the 7, 8, and 9?
Private respondent, Lordship.
Private respondent. But last time we asked them whether they are in service or not. And it appears that they are till this passing of the order by the learned single judge, these people were in service.
Lordship, today we are going to file reply in this case, Lordship.
But we propose to stay this order.
Lordship,
And what about Mr. Consul? This letter dated 25/10/2024 along with your IA. It is in relation to only 3 persons.
Yes,
What
sir,
about the other 3?
Initial B, my lord, we are released. 1, 2, 3, 5, 10,
How many persons have been released?
C.
And what about the other 3? Appellants are 6 in number.
Other I don't know, my lord.
Appellants are 4 in
See.
number. Actually. Number.
One, I need to take those missing. Yeah. One, I need-
What about the this appellant number 4? Bornali Pegu.
I'm not sure, my lord, I heard that she is expired.
Yes.
I heard, but I have no confirmation, my lord.
Who is appealing for respondent number 1 to 6?
The CDPO Barkhana, Lordship has filed an affidavit on the 22nd. So there he says that 7, 8, and 9 are working.
7, 8, and 9.
Respondents,
Madam, what about these appellants?
that the affidavit is silent.
You are in receipt of this copy of this application. That IA which is under consideration, you are in receipt of this IA number 3542.
Yes, but challenging the 25, 10, 20.
Yeah.
Lordship,
This is by the CDPO,
yes,
Dakukhana CDPO.
yes.
And you received the information from who?
Dokakana CDPO.
Same.
Yes, same.
So what about this? They are claiming that they were released, that they are released from service only on 25/10/2024 means they were in service till the order passed by the learned single judge.
Lordship.
What is the response to that?
Lordship, I'll obtain instruction.
The matter comes upon for consideration of the IA number 3542 of 2024. Referred on behalf of the appellants. Wherein it is stated that the appellant number 1, 2, and 3 were in service on the strength of stay order passed by the learned single judge till 25/10/2024. It is noticed that the learned single judge has passed the interim order on
Four, 6, 8. 24.
6/8/2024. On last occasion, this court has directed the respondent number 1 to 6, counsel for the respondent number 1 to 6 to apprise this court that if the appellants were working as Anganwadi worker till the final disposal of the petition on the strength of the stay order passed by the learned single judge in the petition. Full stop. No response to the statement made by the counsel for the appellants that the appellants were in service. Appellants number 1, 2, 3 were in service on the strength of the stay order passed by learned single judge
May
at the
submit
time of passing of the impugnment.
along with reappeal, litigation affidavit was not annexed, my lord. I filed the affidavit on today, my lord.
Fine, okay. Yes, we are granting you liberty. We will consider your request for vacation of the stay order even if we are passing a stay order.
My lord, may I just argue, my lord, for 1 minute, my lord, you will lordship allow me, my lord. Yes, my lord. Lordship kindly come to test 63.
Yes.
My point of argument on 3 points. One is he is not from the residence, which is as per point number 2. This is specific point. And at the time of my lord, they have produced some fraudulent documents. And third, my lord, they have manipulated, my lord, that comparative statement, my lord.
When they were appointed,
They are appointed on that 2009.
2009.
Yes, my lord, 2009. And thereafter in 2015, my lord, there is a, my lord, inquiry, my lord. As per that inquiry, my lord, it's categorically stated that this thing has been happened. Thereafter, my lord, interim order has been passed. And my lord, thereafter, my lord, they were released from the post, my lord. But subsequently, they filed a writ petition, my lord. On that research, interim order has been passed. And that interim order was not extended, my lord. If you're
Not
Extended, yes.
I'm sorry, your lordship, my lord.
even though, sir, whatever it may be.
Yes, my lord.
Now they have been released on only on 25th of October 2024.
Yes, my lord. I'm coming. Now, next point, my lord. That is not important, my lord. My humble submission before the case was dismissed. This writ petition was dismissed. And after dismissal, my lord, by following the order of this honorable court passed by the single judge, my lord, he was released and I was appointed, my lord. Now I am holding the post.
No.
Oh, maybe.
1 point is that, my lord.
They work from last
Lordship,
10 years, we'll consider whatever they play.
I am showing one thing, my lord. If your lordship go to the affidavit in opposition, why this affidavit was not filed before that? They have manipulated the record, my lord.
Which record?
The record
Initial appointment.
there at
At the
the
time of their initial
at the
appointment.
time of initial appointment,
Yes, we will examine.
yes, my lord, page 40, annex
We'll
6.
examine it. We'll examine it.
Lordship, kindly look to the
At present, we are only.
my humble submission before the lordship is that, my lord. I am very so.
We are
I'm-
only saying
Yes, ma'am.
that since they
Yes,
are
ma'am.
king from last 15 years, what meetings can be settled in
My
their
lord,
favor?
when initial entry has been illegal, everything is illegal, my
Yeah,
lord.
that's right. We'll consider.
Because of the interim order passed by this honor, they are working, my lord. Uma Devi said, if someone is working on the basis
How
of.
Uma Devi is applicable?
Yes,
in
my
this
lord,
case,
paragraph
it's a
53.
Anganwadi worker.
Paragraph 53 said, if a
We
person
are
is
simply
working
paying them on
without-
they are not in
Yes,
regular
ma'am.
service.
if a person is working,
We'll consider it. We'll consider.
my humble submission before your lordship, your lordship may fix on day after tomorrow along with the affidavit in opposition file.
We'll fix it day after tomorrow, but today we are going to stay this one.
If your lordship stay, my lord, I was also working now.
Both of you work. It's
I'm
better for the
working, my lord.
It's better for the Anganwadi.
And my lord, I am judgment of the apex court. A fraud document obtaining the job, my lord, that cannot be done. No. That your lordship kindly go to the desk.
Consider it at the time of final hearing.
My lord, my learned senior client has got the job obtaining, my lord, producing fraud document. They have initially appointed the certificate of the Gaura. That was also forced. Then second point is that comparative statement has been forced. Everything is the inquiry report has come, my lord. Thereafter obtaining that fraud document, my lord, they have appointed, my lord.
Not rejecting your arguments. It is
My
open
humble
for you
submission,
to argue all these things.
If
at
your
the
lordship
time of-
state these things, my lord, my service will be hampered, my lord. Where I am now
We'll
and
make
service.
it clear that
My lord,
service will not be important.
yes, my lord. My service will not be hampered. Yes, my lord.
Appellant's number 1. Stop. At this stage, learning council appearing for the respondent number
789.
789 has submitted that after passing of the impugned order by the after passing of the impugned order by the learned single judge, the appellant number 1, 2, and 3 were released from their engagement while order dated 25/10/2024, and the petitioners were appointed and the respondent number 7, 8, and 9
Yes, sir.
were appointed in their place. Be that as it may, from the facts of the case, it is clear that that the appellants number 1, 2, 3, who were appointed as Anganwadi worker in the year 2009, continued to work up to 25/10/2024. Full stop. In such circumstances, we deem it appropriate to stay the effect and operation of the order dated 25/10/2024 passed by the Child Development Project Officer, Daku Khana, ICDS Project Daku Khana, whereby the appellants have been released as Anganwadi worker with immediate effect. Full stop. It is made clear that if the respondent number 7 and 8, 7, 8, and 9 have been appointed in place of the appellants number 1, 2, and 3, their appointment may also not be disturbed. However, the CDPO Daku Khana may assign them work at a different Anganwadi center nearby to the Anganwadi centers in question. Stop. Leave the matter after in the month of January for admission.
Right. In the meantime, my lord, writ petition maybe, my lord, affidavit in opposition file in the writ petition, my lord. Tell us call the record of writ petition, my lord.
Why?
Because they have not annexed the affidavit in opposition of the writ petition.
You annex it.
Yes, fine. I shall annex.
Recording
Yes,
is
sir.
there, my lord. Recording will, in the appeal, the recording automatically come.
Normally, my lord, what happened,
What
we
happened?
know, my lord.
Okay,
All
file.
the documents shall be
Whatever the
filed.
documents.
Yes, my lord.
File it.
Yes, fine. That is the rule, my lord. That's my understanding, my lord. Yes, sir. Yes, sir.
I and number so and so is disposed.
May I please your lordship. Lordship, I am seeking apology for interfering, lordship. Lordship, in item number 2, I was appearing on behalf of Mrs. A. Gayan, CGC Council. I just received instruction that National Commission of Indian System of Medicine have their own council, lordship.
Who is that own concept?
Lordship, maybe the notice is not.
Whatever
served
may we
upon them.
inform them that we have accepted the notices and inform that National Commission they'll engage their own concept. What's the
Lordship.
problem?
Lordship,
Inform them.
obliged lordship.
Item 9.
In this case, for an adjournment,
Notice returnable 6 weeks registered AD.
obliged, my lord.
Item 10.
Notice returnable 8 weeks registered AD.
Item 11.
But the I is for condonation of delay. No? There is delay of 229 days not in preparing the agreement. It has come for the first time. Lordship,
Yes, say which judgment?
well, the against the judgment, Lordship will find it at page number.
That compassionate appointment?
No, my lord. The 116.
Notice returnable 6 weeks registered AD.
For admission, item 13 to 15.
About 12.
When already.
Item 13 to 15.
Who is for the state?
I'm for the respondent,
Which respondent?
my lord, the private respondent, the original writ petition.
Concern.
My lord,
Why you have come before this court? They are simply seeking that
they are seeking
their application be considered.
appointment,
They
my
are-
lord,
This is
there is item number 13, 13 to, now this is an appeal
13 to
file.
15.
I file an appeal, my lord. Bank has filed this appeal.
That's the election. There's some delay on it, right? Hmm.
Yes, what do you want?
I am for the respondent. The bank has come in appeal, my lord.
Yeah.
Now, my lord, the writ petitioners had approached this honorable court. They had participated in a selection process. These applicants are all sweepers, my lord. Now, advertisement was made. Interviews were held. Then, my lord, the bank took a stand that they are keeping in abeyance the recruitment process. That was,
As per the instructions from the central government.
yes, my lord.
Yes.
Now, my lord, the whole question comes first, whether that central government advisory will have any retrospective effect affecting the,
What's the retrospective effect?
my lord, the circular or advisory was issued in the year 2015. When the,
Yeah, ultimately you participated in that, also attended the interview process or whatever it may be. What is your right after all?
my lord,
Even though
my,
if your name is also figured in the select list, that law is very clear.
yes, my lord, that is
That-
clear, but I have a right to consideration. Now,
Right to
if you're,
consideration, you've already been considered.
then my lord, not to,
What is the right of appointment, sir?
my lord, my right, lordship, your lordship, I'll place two decisions which says that if the authority initiating the appointment,
Appointment.
I mean, the selection process does not conclude it, there must be some valid reason and strong reason. It cannot be done
Is
arbitrarily.
it not a valid reason that the central government has stopped this practice?
And they have not, my lord, lordship may have a look at the decision taken by them, the board resolution, which your lordship will find at page 96.
96.
Now, here, my lord, in the memo of appeal, my lord.
Memo of appeal 96. is
Mr.
not
Chakravarti, which appeal? Writ appeal?
Writ appeal 60 of 24.
60 of 24. Give it the 60 of 24.
Item 14.
Yes.
Now, my lord, we'll see. Before that, your lordship may have a look at the central government advisory, which is
92.
96.
96. We have to look into this or central government advice.
First central government advisory, which comes at page number 93.
93. Okay, read.
I am directed to refer to the announcement made by the Honorable PM in his address to the nation on the occasion of Independence Day on the subject cited above, and to say that the Committee of Secretaries chaired by the Cabinet Secretary in meeting held on 13/11/15 has recommended discontinuation of interviews in the recruitment process in public sector banks for junior level posts by the deadline of 31/12/2015. So, my lord, my humble submission is the decision was taken to discontinue the process by the deadline of 31/12/2015. That means after 31/12, there cannot be any process of recruitment by way of interview. Now, here in this case, the interviews were over before to coming of of this advisory. Now, in that event, what the bank decided, your lordship will see at page 96.
What is the second para of this order?
My lord. Accordingly, it has been decided to advise all PSC to take necessary action with the approval of the respective boards if necessary to discontinue interviews in the recruitment process for the clerical and sub-staff posts in public sector banks by 31/12/2015 and disseminate the information to all stakeholders accordingly. So
What is the resolution of the bank?
96.
Read.
My lord, the proposal for amendment of recruitment policy, discontinuation of interview and recruitment process for clerical and subordinate staff as detailed in the agenda. It was resolved that approval is accorded for amending the selection criteria by discontinuing the interview process for recruitment in clerical grade and subordinate cadre, excluding sweepers. So the petitioners before lordship had applied for the post of sweepers and proficiency test along with a written test for test be conducted for recruitment of armed guard and peon cum driver. Also resolved that till sir receipt of clarification permission from so the process of recruitment sweepers may be kept in abeyance. So that was taken in 2016 and till date, my lord, they have not come up with any procedure. Although the writ petitioners, some of them who participated continued to work as a part on contractual basis.
That is not, that doesn't give you any right to be selected once they have decided.
No, that decision was not to discontinue the process. They had decided to keep it in abeyance by relying on this particular advisory, which in my respectful submission could not have affected the selection process. My lord, I'd like to place certain decisions, my lord, which, my lord, it says, to 1993 SCC. Now, my lord, I'll refer to paragraph 11 of the judgment of 1993 SCC 157. It says where selection process is initiated by issuing advertisement inviting applications, selection should be regulated.
This is judgment in MP Bevin Katti.
My lord. Yes. Devin ka state of Karnataka, my lord.
What is the, which relevant para is?
Paragraph 11.
11. Yes.
My lord, there is the paragraph starting for, there is yet another aspect. My lord, in between, generally a candidate has a right to be considered in accordance with the terms and conditions set out in the advertisement as is right.
There is yet another aspect of the
Yes.
question. Read from here.
Where advertisement is issued inviting applications for direct recruitment to a category of posts and the advertisement clearly states that the selection shall be made in accordance with the existing rules or government orders. And if it further indicates the extent of reservation in favor of various categories, the selection of candidates in such a case must be made in accordance with the then existing rules and government orders. Candidates who apply and undergo written or viability test acquire vested right for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement insults a contrary intention. Generally, a candidate has a right to be considered in accordance with the terms and conditions set out in the advertisement as this.
Judgment is that.
Now, my lord,
If they change the rules after this, then only this judgment is available. Now they have said we have decided not to continue with this recruitment process. How can you force them?
no, my lord, they have not decided not to continue. The decision is, they have not decided that they will not continue with this particular selection process. They have kept in abeyance. If your lordship goes to the advertisement, the selection procedure or the circular by which the sweepers were selected or required to be appointed, the only process of selection was interview. Now, my lord, if this advisory is applied, which says selection should be by way, the interview should be discarded and it should be done in a different way. Now, on the face of that advisory, my lord, it says that it will be applicable with effect from a cutoff date of 31/12/2015. So the question is, the advertisement was issued prior to the circular. Then, my lord, the date on which the circular was made into operation, the interviews were already over. Now the question is, can this circular come in the way for them to take a call that we are keeping it in abeyance when the circular does not apply retrospectively, cannot have an effect on that recruitment process? Now, the Supreme Court in another case, my lord, has held that these circulars do not have any retrospective effect. It is true, my lord. The candidates participating in a selection process doesn't have any right, but they have a right to be considered in accordance with the law or the rule that was in force when the circular was issued. Now, if this advisory does not have any retrospective effect, which your lordship, I'll have placed two decisions, my lord.
Yes.
It says that circulars do not have any retrospective effect. Paragraph 30. My lord, paragraph 26, the limited question which has been raised for our consideration is to whether the rates prescribed by the appellant under circular so-and-so would be applied retrospectively or be effective from the date. Paragraph 26. Now, paragraph 29. It is settled principle of law that it is the union, parliament and state legislature that have plenary powers of legislation within the field assigned to them, and subject to certain constitutional and judicially recognized restrictions, they can legislate prospectively as well as retrospectively. Competence to make a law for a past period on a subject depends upon present competence to legislate on that subject. By a retrospective legislation, the legislature may make a law which is operative for a limited period prior to the date of its coming into force and is not operative either on that day or in future. Then 30, the power to make retrospective legislation enables the legislature to obliterate an amending act completely and restore the law as it existed before the amendment. But at the same time, administrative executive orders or circular, as the case may be, in the absence of any legislative competence, cannot be made applicable with retrospective effect. Now, my lord, if that is the law, that executive orders or circulars cannot be made with a retrospective effect, then the advisory of 2015 cannot have an effect on the date on which the advertisement was issued, cannot have a effect on which the interviews were held. It is only at the stage when the decision on the recruitment process was to be taken, this circular was made applicable. Now, my lord, the selection process for the post of sweepers, which your lordship will find.
That you have already said, the interviews have also been taking place, everything was there, but they have not, they have decided not to fill those posts.
No, that is the question, my lord. They have not taken that decision. They have
kept in abeyance.
They have kept in abeyance in 2016 and we are in 2024. Till date, they have not replaced, which the learned single judge has held, that they have not come up with any present recruitment policy prescribing the, my lord, procedure. On the other hand, they are engaging and getting the work done. There is a sweeper, the post of sweeper or the works of a sweeper is very essential in any bank.
That is for them, whether that is essential for them or not.
No, my lord, they are exploiting. On the one hand, they have taken.
They may clean their whatever it may be on their own. How can you stop them?
Exactly, my lord. They are using people, but not giving the effect of a full-time appointment. That is what the learned single judge has held. So they are in that way, they are exploiting. So the main question which calls for a determination by your lordship is whether that advisory of 2000.
That's why only consider it, not at the admission stage, we'll consider it at the time of hearing. Whatever the main consideration, now you are arguing as if it is a final hearing. It's only for the purpose of admission.
Because my lord, this person's,
Okay, this these appeals are referred against the by the appellants being agreed with the order dated 15/11/2023 passed by the learned single judge. In this order is the same or
The
different?
common judgment.
Common
There are three writ petitions which has been filed. One is two thousand
Okay,
eighteen.
yeah, the writ petition number 3394/2018, 1735/2020, and 5749/2021. Stop. The respondents in the writ appeals have preferred writ petitions raising a grievance that the bank has initiated the process for selection of sweepers. However, later on, they have kept in abeyance the said procedure on the pretext that the central government has issued an advisory to discontinue the selection process on the basis of interview on the learned single judge has ordered that the respondent, that the appellant bank is required to complete the process of selection. Once it is started, it is also to be noticed by the learned single judge that whatever the advisory issued by the state government was issued after
Central government.
the
Advisory issued by the central government ministry.
central government.
Central government advisory.
Central,
Yes, your lordship has said advisory issued by the state. Not,
central government,
yes, that's.
central government. Whatever the advisory issued by the central government is after the selection process was almost over, it stopped. And concept of the appellants have submitted that simply because the respondents have completed the selection process, they don't have any indefeasible right to claim appointment once the board of directors of the appellant bank has decided to discontinue, to keep the selection process for sweepers in abeyance. It is contended that the learned single judge has added issuing direction to the appellants to conclude the selection process, full stop. Per contra, learned concept appearing for the private respondents has vehemently oppose the writ petition and has argued that learned single judge has rightly ordered for rightly directed the appellants to conclude the selection process and grant appointment to the respondents on the basis of the said selection process. It is contended that the state government, that the appellants cannot take recourse of the circular or the advisory issued by the state government, which is
central government.
Which is prospective in nature. It is contended that prior to the issuance of the said advisory, the selection process was already over. It is further argued that the respondents has a indefeasible right for their consideration on the advertising post as per the existing rules and the regulations, which were as per the rules and regulations which were in vogue at the time of issuance of advertisement and the conclusion of the selection process. Full stop. Having heard the learned counsel for the parties, we are of the view that matter requires consideration, hence admit no need to issue notice as parties are already represented. In the meantime, effect and operation of the impugned order passed by the learned single judge shall remain stayed.
My lord, we have pray for an early hearing in this matter.
This writ appeals for hearing in the month of February 2025.
Can I be in January, my lord? They are poor sweepers, my lord.
It's December is already, you have winter vacations. Then again, Bihu way breaks. Better. I mean, February.
This appeals, all three appeals.
Yes, sir.
And if you-
Item 16 and 17.
But if you're challenging a common judgment on order, Lordship, whereby the Lord.
What is the difference? They have been selected by a screening committee constituted by the state government. Simply because they have not been selected by the APSC, therefore they are not entitled for the trade protection. This is absolutely discriminatory.
Lordship, that is not the fact, Lordship.
That is
Lordship,
only.
initially, Lordship, before converting to the Jorhat Science College to Jorhat Institute of Science and Technology, Lordship, after conversion to Jorhat Institute of Science and Technology, it was the administrative affairs was managed by the Lordship. A society was formed. It was formed under Lordship the Societies Registration Act. And Lordship, the objects of the society, amongst others, was Lordship to appoint the personnel with approval of the government. This approval of the government was there. It was a society.
Even though if the screening committee was selected, approval of the state government is very much necessary, purely funded by the state government. Society was purely funded by the state government. The persons were selected by the APSC were appointed prior to the this
Conversion.
prior to that. So what makes a difference?
But Lordship, the APSC advertisement, Lordship, clearly says that it will be of the government for the government employee, for government against government appointment. But here the
Who
appointment
was sanctioned those posts?
sanctioned by the government.
Then
But Lordship,
sanctioned by the government. Screening committee was constituted by the government,
Lordship,
headed by the government officers,
Lordship.
purely funded by society was purely funded by the state government. What makes the difference between that?
Lordship, may I draw your Lordship attention to page 106, the conversion order. 106. May I read it, Lordship? Lordship, it says of the 30th December 2016, the government of Assam is pleased to declare that the administrative control of the Jorhat Institute of Science and Technology, Jorhat, is hereby brought under the government of Assam Higher Education Technical Department with immediate effect. Henceforth, the college will come under the category of full-fledged government engineering college. But if the full-fledged government engineering college, the word has been used here. Then subsequently, Lordship.
And the persons who have been granted trade protection,
Lordship.
who were those persons are appointed when?
2012.
Last
2012.
2012.
12.
Prior
By
to
the
this,
by the APSC, by the APSC.
Prior to taken over by the state government,
Lordship.
then
But it was through APSC.
whatever it may be, APSC or the selection committee, how it make a difference? Simply because they were selected by the APSC, they are entitled for.
But their advertisement,
These are not
but their,
entitled.
Lordship, the advertisement clearly shows, Lordship, in the writ appeal number, advertisement is annexed there of APSC, 344 writ appeal, Lordship. The advertisement is annexed at page, Lordship, 112. Of writ appeal number 344, Lordship.
Yes.
The advertisement says, Assam Public Service Commission invites application from Indian citizens defined under Article 5 to 8 of the Constitution of India for the undermentioned
What?
post. It's not the writ appeal.
1-1?
Lordship,
Page
112
112 is not there.
of 344. Writ appeal 344. Lordship. Next, item number 17.
Then the, you are appearing in this 321 also.
Lordship, both
So
state.
why don't you have this file? 321.
Lordship.
It is listed prior to that, then argue
Lordship.
it out.
Lordship, the APSC advertisement was not there, Lordship.
Or not there, then.
It was not there, Lordship. Definitely.
Extract it there, my lord, as page 112.
Yeah, read.
Yeah, at page 112. Lordship. Assam Public Service Commission invites application from Indian citizens as defined in Article 5 to 8 of the Constitution of India for the undermentioned posts under Assam government in the scale of pay as indicated against each and carrying usual allowances as admissible under the rules of government of Assam. This is clearly said as admissible under the rules of government of Assam. Whereas the advertisement of the Lordship, the persons who were
What is
appointed,
that? That advertisement?
that advertisement of Lordship in the writ appeal of 321, I'm sorry, Lordship.
It is not in this.
It is there, but I have not gone through thoroughly here. That's it is also there. But in 321 Lordship at page, advertisement is at page 102.
Yes,
103 is the issuing authority.
read.
Yes, Lordship. Jorhat Institute of Science and Technology, Jorhat, invites application from Indian citizens as defined under 5 to 9 of the Constitution of India for the under the mentioned post in the scale pay as indicated against each and carrying usual allowances as admissible under the rules of the Jorhat Institute of Science and Technology, Jorhat. It is clearly said that it is be governed by the Jorhat Rules and Regulations of the Jorhat Science and Technology Society
Society, the rules were approved by whom?
by the government, by the. And Lordship, it was issued, advertisement was issued by the Lordship, the Director of Technical Education on behalf of the government,
On behalf of?
of the governing body. On behalf of the governing
Director
body.
Technical Education on behalf of the.
And Lordship, appointment letter, Lordship, if Lordship comes to 104,
Yes,
appointment letter.
yeah.
Here, Lordship, appointment letter says, Lordship, on recommendation of the selection committee for appointment of post of lecturer of Jorhat Institute of Science and Technology, Jorhat, the following persons are hereby appointed as lecturers as detailed below in Jorhat Institute of Science and Technology, Jorhat, in the scale of so and so, plus other allowances as admissible as per rules of the society from the date of joining. It is as per the rules of the society. It was clearly stated in the appointment order, advertisement, everything, Lordship. So, Lordship, the society was a separate legal entity. Though, Lordship, the governments, the employees were the member of the society for the functioning administration of the college society, college Lordship. But that pay protection, Lordship, cannot be, Lordship, that is
That's all.
Lordship. And Lordship, pay protection is given to a person when it is transferred from one government employee to the other department. Lordship.
Rules for orders.
Obliged, Lordship. Both are same, Lordship. Same common.
My lord.
Item 18. May I please the lordships, similar writ appeal lordships, it was discussed, but
I did not find our submissions recorded, but what considerations from the government lordships?
Yeah,
We did not find what considerations government had considered that has not been reflected in the board the judgment.
nothing doing that.
Here, our case is
Analogy
that,
is the same.
our case is that lordship, we have submitted objections. As per, on receipt of objection, deputy commissioner has to forward to the government. Government will consider as per provision section 3 of the Municipal Corporation 2022 and read with article 243 Q2. And government, here the case deputy commissioner has considered. And subsequently, he again considered, but government, judgment reflected government had duly considered,
Government-
but nothing,
government in the case. the
what
deputy
considerations
commissioner-
had come from the
Just a
government.
minute. The deputy commissioner has forwarded that I considered, then the state government was not satisfied with that. The state government called further explanation from the deputy commissioner, then the deputy commissioner has sent it to the state government and then the state government has passed it.
Yeah, that duly considered, but what consideration had come from the government that is not reflected in both the judgment lordship.
So this is, the process is the same.
We have, my client wants to know what consideration had come from that government
was
lordship.
from the-
Since our objection is in, the consideration is not in consonant section 3 of the municipal corporation.
It's been
Even
decided, sir, it is
lordships,
decided.
lordship has the power to
Everything-
recall
everything
even
has been
if it is
taken
not
into
considered.
consideration. The judgment was passed by the
Yes.
common order
Lordships,
by the learned single judge
just lordships,
in bunch of writ petitions.
lordships.
One of the writ petition has been decided, what remains then? Can't make out a
What?
case. Okay, this writ appeal is preferred by the petitioner being agreed with the, by the appellants being agreed with the order dated. What's the date of order?
Yes, lordships,
Judgment and order dated
4/11/2024.
24/9/2024. Passed by the learned single judge in bunch of writ petitions, including the writ petition filed on behalf of the appellants. This court's wide order dated 4/11/2024 passed in writ appeal number 371/2024 has dismissed the writ appeal preferred on behalf of the appellants. Whose writ petition has been, whose writ petition number
3892 of 2023.
3892/2023. No. This is not, the appellants herein as the petitioner instituted. Whose petition number 595/2023 has been dismissed. Stop. Taking into consideration the fact that the identical appeal against the impugned judgment has already been dismissed by the division bench of this court. Wide judgment dated 4/11/2024. We dismissed this writ appeal also in terms of the order dated 4/11/2024. Passed in writ appeal number 371/2024.
Obliged. Item 19.
And counsel for the petitioner has submitted that. The Leonard Single judge has aired in observing that the appointment, that the temporary appointment of the respondent can be treated as office boy or what?
Boy service,
Boy service
for the purpose of pension.
in the canteen operated by the employees of the FCI. And the council has submitted that there is no provision for appointment of boy
Service, as boys, anybody else.
boy service in the FCI. Full stop. Issue notice returnable on so and so. In the meantime, effect and operation of the improved order shall be maintained.
Lot.
Item 20, along with item 30 and 31 of supplementary list.
Well, in item 20, I am for the respondent. In item 30, well, we are for the appellant.
Lordship, kindly pass over the matter for timely notice. Lordship, kindly pass over the matter for timely notice for appellant lordship,
Which matter?
item 20 and 31.
Item
Item 20
20
and 31.
31. And you are for item number
Well,
30.
in item 20 and 31 for the state respondents, and item 30, well, we are for the appellant. Again, the same,
You are challenging the same order.
same order, well, we have also challenged.
And counsel for the appellant has submitted that the Leonard Single judge has added. Interfering, add in interfering in the matter. It is submitted that the London Single Judge has recorded a finding that the process adopted for allotting the work of the respondent number 5 is not in accordance with law. And it council has submitted that there is no requirement for a bidder to furnish the details from whom he is going to purchase the materials. It is submitted that the state government, after taking into consideration the fact that the successful bidder was L1 and he is capable of carrying out the construction work has allotted the contract in accordance with law. Having heard the London Council for the land out of the view that matter requires consideration, hence issue notice. Mr. Deanath put in appearance on behalf of the
1, 2, 3, and 4, madam.
1, 2, 3, and 4 in writ appeals number
In item number Readable 386, 2024.
In with the pin number,
And item number 31.
number bolo.
Petition being
Six
and
and 388 of 2024.
And 381 malad we are for the appellant.
And for the appellant in 381 of 2024. Stop. Let notices be issued to the other respondents in the writ appeals. And you are appearing, Mr. Ken Chaudhary, you are appearing
I'm appearing for the appellants, my lord.
appellants and respondent in this writ appeal, state government writ appeals.
Yes.
Which respondent? Mr. Ken Chaudhary, senior
I've been made pro forma respondent, my lord, in the state's appeal.
And in writ appeal number 381 of 2024 on behalf of performer respondent number
Two.
two. Let notices be issued to the other respondents. In the meantime, effect and operation and due notice passed by the learned single judge shall remain stayed in all these appeals.
In fact, my lord, that recommendation of the committee was there.
Item 21.
Lordship, we require some time, Lordship, to look into the grievance of the petitioner.
You require some time for?
To look into the grievance, Lordship, here the petitioner is getting the retirement benefits, but he is disputing the,
Seeking promotion from 2000.
yes, Lordship.
So the learned single judge has already said that what grievance.
Yes,
we are going-
Lordship, here, why the department has not been able to assess, Lordship, we just require some time to address the issue, Lordship.
Yeah, issue notice,
Lordship.
then counsel. Mr. So-and-so put in appearance on behalf of the respondent,
1 to 4.
1 to 4.
Yes.
And other respondent, is there any?
Lordship, AG.
Respondent is appearing for respondent number 5. Service is therefore complete. All other respondents are there or?
Only 1 to 4.
Service is therefore complete. Just for admission after 4 weeks. In the meantime, when it comes in for the respondents may file a response to the writ appeal if desired so.
Item 22.
May it please your lordships.
We hear it along with that PI.
My lord, my submission, absolutely, my lord. My only submission is, my lord, there is some urgency in the matter, if your lordship. Well, I think, my lord, let the government react to this, my lord. Only thing,
Then issue.
can I place
Then-
one paragraph from one judgment, my lord? One paragraph. Yes. Hey, to Diog na. 1984 2 SCC 292. Two nine two. My lord will kindly come to paragraph 4 at page 296.
Yeah.
Entry 40 of list 1 of the 8th schedule to the constitution is lotteries organized by government of India or government of a state. Very important. Entry 34 of list 2 of the 7th schedule is betting and gambling. There is no dispute before us that expression betting and gambling includes and has always been understood to have included conduct of lotteries. Quite obviously, the subject lottery is organized by the government of India or government of a state has been taken out from the legislative field comprised by the expression betting and gambling and is reserved to be dealt with by the parliament. Since subject lottery is organized by Government of India, Government of the state has been made a subject within the exclusive legislative competence of parliament, it must follow in view of Article 246, 1 and 3, that no legislature of a state can make a law touching lotteries organized by Government of India, Government of a state. This much is beyond the controversy, and Maharashtra legislature has acknowledged the position as indeed it must in section so and so. It is an act to control and tax lotteries and to tax prize competition in the state of Maharashtra. Section 32B expressly provides that nothing in the act shall apply to lottery organized by central government or of a state. So pursuant to entry 40 of list 1, my lord, it speaks of only lottery organized by the Government of India and the state. But otherwise, my lord, entry 34 of list 2, under the heading betting and gambling, it includes the power of the state. So since there is no legislation, under Article 162, they can give the permission. So that would be my argument, my lord. Yes.
Notice.
My only thing is, my lord, if your lordships could make the notice returnable within 10 days, my lord. Some urgency, my lord. This is an event which is taking place for years together, my lord.
Returnable 2 weeks. This, and the expiry date, this along with the petition number
29, my lord.
29/2024.
4.
29/2024.
Yes, my lord. Yes.
29/2024.
And meanwhile, state will file their counter, my lord. It's a question of law, essentially.
Already, in fact, that rejection is very elaborate. Taken all the grounds. SL before the stand before the Supreme Court,
Including the order. My lord, the Supreme Court order was in a different context. Under the section 5 of the new act, if a state wants to debar a lottery of any other state, then state must not also hold lottery. That is how Article 14 and 301 has been interpreted in BR Enterprises case.
Item 23.
Who is for the state government?
I am appearing for respondent number 2, lordship.
Madam, what?
One is only commissioner has been written, lordship.
Why he is not taking steps for that?
Lordship, I think there is election going on. I shall take instruction. By election
going
no
on.
go, lordship.
Find your response.
Lordship, I shall take instruction.
London Council, Mr. So-and-so appearing for the deputy commissioner in all the petitions is directed to complete the instructions by the next date of hearing. Copy of the writ petition be supplied to her during the course of the day. Less after 2 weeks.
Lordship, one has to specify who is commissioner, lordship, then I can.
Yeah,
No, go.
No, one, respondent 1.
the respective district commissioners in all the writ petitions.
Respondent 1, commissioner 2.
Item 24.
Similar, 24, 25 and 26. Similar.
All these 23, 24, 25 and 26 respective, all the district commissioners you are appearing now.
Item 27.
This matter has, after the delay was unknown, this has come for the first time. We'd like to file a short reply, madam. Your lordship, may allow us 10 days time.
You are appearing for,
All the respondents.
this is also appearing for all the respondents. Please, time to file counter to the writ petition, writ appeal. Time period for is granted. List all. It's in January.
Supplementary list, item 29.
Wait, in this case, what IA has been filed for impediment, that has not been on before this honorable court.
Consider it separately.
Lordship, may I be taken one month?
So far as regarding this modification is concerned, we have already disposed of certain applications. We are disposing it off.
Lordship. We have already annexed this order, your Lordship. 176 only.
176. 173.
Impeding file also nahi. Into defective है, into का नहीं है, नहीं लो. नहीं, थोड़ा को लेते शीशे ठीक से नहीं.
No, perhaps the impleading has not been listed because first they, perhaps,
Let me reading.
there is no problem, Miller, normally.
You mean to say that both the application should be decided?
No, no, what I'm saying is that, Miller, first he'll implead, then he'll make it, in other cases.
Application for vacation.
Yes, whatever ordered in the IA for in the modification, the IA for impleading comes along, that's what.
When you.
For Wednesday only, there is some defect is occurred in impeding petition. We will rectify tomorrow, not tomorrow.
This tomorrow along with the another IA preferred on behalf of the applicant.
Lordship.
Much obliged.
Daily list for hearing, item 28.
Bed Procedural. My lord will first come to page 96. The settlement order which was interfered by the learned single judge. Yes. Now, this is 18 November 2019. Now, I'll have your lordship's kind attention towards the bottom, my lord. It appears, has your lordship's got it, my lord?
Let's start from the beginning.
No, that's why this is the settlement order.
Let's
Okay,
start
okay.
From the beginning.
Oh, yes. From the perusal of records, it is seen that on expiry of the current lease, DC Kamrup Guwahati issued NIT dated so-and-so for fresh settlement fixing 8/7/2019 as the last date for submission of tender with annual government revenue of rupees 1,07,142 for settlement of Kamrup Pragjyotispur Brahmaputra Fishery. In response, 5 societies submitted tender. DC forwarded copies of the tender with documents along with comparative statement with letters dated so-and-so. The tenders have been scrutinized and status of each bid is shown below. Messrs. 3C Lower Part Brahmaputra MMCS Amingaon district has offered the 5th highest bid of 7,77,000 and odd for 7 years, that is total so-and-so. Society has submitted Bakija clearance certificate and neighborhood certificate in individual name, and it has not submitted call deposit. So the bid offered by its invalid tender and rejected outright. Messrs. Poop Maloibari Mocha Bebokhai Somiti, village so-and-so has quoted second bid of 51 lakhs and odd for 7 years. Bakija certificate is in individual name. 100% actual fisherman certificate not issued by competent authority, that is ARCS. List of members prepared by secretary of the society is endorsed by so-and-so branch, DC's office Kamrup, which is not acceptable. Neighborhood certificate not submitted, hence it is not a valid bid. Chandrapur Ansolik Means Samabhai Samiti Limited, Chandrapur has offered third highest bid of rupees 50 lakhs and odd. Fishing experience certificate has not been issued by competent authority, that is DFDO Kamrup. Instead, it is issued by Circle Officer Chandrapur. It appears that society is at a distance of 1 kilometer from the fishery, as per report of CO Chandrapur dated so-and-so. Now, this is the appellant mirror. Messrs. Number 1, A part N2, upper part Brahmaputra Fishery Cooperative Society Panikati has offered first highest bid of 38 lakhs and 63,000 for 7 years. Society has submitted all documents which are found to be in order. As per report of the CEO, members of the society reside on the bank of the river fishery. Now, this is respondent number 10, writ petitioner before the learned single judge. Messrs. number 11, number part 5, along Nodi Ansolik Means by Samiti, village so-and-so, Chandrapur has offered highest bid of 60 lakhs at the rate of for 7 years at the rate of so-and-so. The 100% actual fisherman certificate has been issued by DFDO, that is District Fishery Development Officer, instead of Assistant Registrar of Cooperative Societies, and another certificate issued by Circle Officer. That society consists of fishermen, but both the certificates are not as per format. As regards neighborhood issue, highest bidder so-and-so society filed the complaint that the certificate issued by CO has been fraudulently obtained. The matter went to High Court by WPC number so-and-so, wherein Honorable High Court by order dated 19/7/19 directed DC Kamrup to examine the complaint and dispose of by a reasonable order before settlement of the fishery. Accordingly, ADC, based on fresh inquiry by CO, disposed of the matter with a speaking order dated 23/9/19 and came to the conclusion that number 1, part 1, Upper Brahmaputra Fishery is in the bank of the fishery, whereas Messrs. Part 2, Kolong Nodi, that is the respondent petitioner, is located at a distance of 1 kilometer. Further, from the certificate issued by CO on neighborhood in respect of Messrs. Chandrapur Ansolik, it appears the society is located at a distance of 1 kilometer from the fishery. In respect of first and third highest bidder, one document each is not issued by the competent authority. Fourth highest bidder, that is the appellant, has submitted all documents in terms of the NIT. As regards neighborhood issue, in the light of the provisions of Rule 12 of the Assam Fishery Rule, it appears that out of the 3 contenders under the zone of consideration, the fourth highest bidder is more suitable as members of the society reside on the bank of the river fishery, whereas other 2 are located at a distance of 1 kilometer. Considering all aspects of the matter, including neighborhood issue, in the light of the provisions of Rule 12 of the Assam Fishery Rule, government is pleased to settle Praxidis for fishery number so-and-so at so-and-so with effect from the date of handing over possession of the fishery. The Deputy Commissioner will take necessary action accordingly for handing over possession of the fishery to the settlement holder after completion of all required formalities. The order is issued with the approval of the competent authority in the government, in the fishery department, subject to further order in so-and-so in the light of the interim order of the High Court dated in the above noted writ petition. So essentially, my lord, the writ petitioner was discarded on 2 grounds. One, the fishing certificate was not issued by the competent authority, and secondly, fishery is not in the neighborhood of the fishery. Now, the learned single judge, my lord, has basically gone by the higher amount. My lord, lordship had the occasion to deal with the fishery rule matters, my lord. It is a statutory contract. It's unlike a commercial transaction, my lord. The idea is government is prepared to forego the revenue also if the actual fishermen living in the neighborhood of the fishery, if they get a better deal. Idea is to, my lord, empower them through some forms of means of employment. The idea for the state is not to earn revenue. Now, my lord, one of the most fundamental things which I would like to argue in this case is there is no averment in the writ petition that the petitioner fishery is in the neighborhood. That's my first point of attack, madam. If your lordship would kindly come to
1 kilometer doesn't consider to be in neighborhood.
Actually, my lord, that's an understatement. I'll show the report, my lord. That earlier we filed a complaint because they don't belong to this. Their own document will show, my lord, they're in the neighborhood of another fishery. My lord, idea is like, my lord, the fishery rule, it operates like this. In respect of an area of operation, there would be a, my lord, fishery cooperative society. Now, people would normally, they will vie amongst themselves. That's why earlier when societies were less, there is to be direct settlement in terms of proviso to. Now, my lord, with the growth of population, number of societies have come up. Therefore, now they have introduced tender system.
Now, come to this para number 29.
Yes.
The conclusions.
Yes. 1 second, my lord. 54. In fact, para 30, my lord.
Yeah, para
Yes.
59,
Yeah.
para
Yes.
30.
Yes, yes, yeah. The rejection of bid of the petitioners by the impugned order dated 18/11/19 is basically on two grounds. 100% actual fisherman was not issued by appropriate authority, that is ARCS of the concerned district. And secondly, the ground of neighborhood with the finding that majority of the shareholders of the petitioner society reside at village Niz Govardhan, which is situated at 1 kilometer distance from the fishery. So far as the first ground is concerned, the same appears to be perverse ground, inasmuch as such certificate issued by the ARCS has not only been annexed to the writ petition, but there is also fair disclosure by the learned State Council that original records indeed obtained such a certificate. An attempt has been made by Sri Bhattakur that the said certificate annexed as Annexure 6 to the writ petition. The same states that the members of the society are in the neighborhood of certain mahals which do not contain the name of the present fishery. However, the purpose of the said certificate and objections raised pertain to the question of issuing authority as well as the purpose. In the instant case, issuing authority is the ARCS of the concerned district, and the purpose is to certify that all members of the petitioner number 1 are 100% actual fishermen. Therefore, objection raised by the Bhattakur may not be relevant.
So the certificate was there, and therefore the learned single judge, the certificate is there, therefore we are not going to consider.
Yes.
First point.
Yes. Now
Now-
kindly come to the second point.
Yeah.
As regards the second ground, namely neighborhood, the finding arrived at in the impugned order is that majority of the shareholders of the petitioner society reside at a village Niz Govardhan, which is situated at 1 kilometer distance from the fishery. The list of the members along with their address would show that other than the village Govardhan, there are other villages also where members of the petitioner society reside. The mere fact that certain members are residing at a distance of 1 kilometer cannot govern the fate of the society. Further, the decision relied upon by the petitioners have laid down in clear terms that while ascertaining the requirement of neighborhood, the same cannot be done with minute mathematical precision, and requirement is only that the actual fishermen belonging to scheduled caste community reside in the vicinity should get the benefit. In the opinion of this court, the such requirement cannot be tested in golden scale and would depend on the case-to-case basis. This court, in the humble agreement with the interpretation of the expression neighborhood in the context of Rule 12, made by the Honorable Division Bench of this court, the relevant extract of which has already been quoted above in the judgment, this court is of the view that the purpose of requirement is to advance the objective of the rules and not to frustrate the same. The Honorable Division Bench also laid down that term neighborhood does not express any definite idea of distance. No, my lord, there is no dispute about the legal proposition. Now let us come to the facts of the case. Now, if it is the case of the petitioner that they are in the neighborhood of this particular fishery, there ought to be an averment in the writ petition, my lord, because that is a jurisdictional fact. Now please come to the writ petition, my lord, page para 34. Para 34, para 5 of the writ petition.
Yes.
That the petitioners beg to state, at present there are total 114 number of members of the petitioners Samabhay Samiti residing with the operational area of the petitioners Samabhay Samiti, which belongs to 100% actual fishermen community, having its head office at Govardhan, Chandrapur, Kamrup. To that extent, the Assistant Registrar of Cooperative Societies Khanapara has issued certificate stating inter alia that Society of the Petitioner is a registered fishery cooperative society and composed of 100% actual fishermen belonging to Koiborto male Nomokudro community, which is recognized scheduled caste under the constitution of SC in the state of Assam. All persons are actual fishermen. Where is that averment that members reside in the neighborhood of the fishery? Well, this is a jurisdictional fact. If it is not there, if that foundation is not laid, I don't think any building can be constructed. There is none below. Now kindly come to the certificate. Page number 65, my lord. Yes. Certified that number 2, part 5, Kolong Nodi Ansolik Min Samobai Samiti is a registered cooperative society under the Assam Cooperative Societies Act and the rules of 1943, bearing registration dated so and so. The village covered by the society are Dungdung, Kolongpar, Posim Moloibari, Pub Moloibari, Gaon Dimoria, Digarumuk, Dhamkhunda, Dipuzijan, so and so, so and so. This society is a reorganized fishery cooperative society and composed of 100% actual fishermen belonging to Koiborto male Nomohudro community, which is recognized scheduled caste under so and so. Now, this is important. This society deserves settlement as all the members of the society are catching fish. In this connection, preference may be given as practicable to the reorganized fishery cooperative society located in the neighborhood of the fishery mahal number, deposition number so and so, so and so. The society applied for settlement in these areas. They are in the neighborhood of my lord, this fishery, number 25 deposition. So what required by now?
That is not this
No.
fishery.
No. Now, Milord will kindly have a look at the fishery rules for a moment, Milord. Please come to Rule 12, Milord. Except Rule 12, pages may not tell him.
Yes.
Except those referred to in sub-rule number 8B above, all registered fisheries shall be settled under tender system of sale in place of auction, provided that government shall settle 60% category fishery, that's the present one, with special category of cooperative society, non-government organization and self-help group consisting of 100% actual fishermen in the neighborhood of the fishery concerned by tender system. So my lord, if you are not in the neighborhood, then you are not eligible for consideration. Now, my lord, we filed a complaint and that order has remained unchallenged. Now, if your lordship would kindly come to page number, yes, page number 107, my lord. To be precisely at 118. Now, when we saw that they are also participating, then we filed their representation. Since the authority was not disposing of the representation, then we filed the writ petition. I am reading the first subpara. The petitioner herein is one of the tendering settlement process initiated by respondent based on the tender dated so and so for settlement of Kamrup Pragjudishpur Brahmaputra Fishery Mahal. This is the Mahal. The petitioner has approached this court by alleging that respondent number 5, though ineligible to participate in tender process, has been allowed to submit his bid based on forced neighborhood certificate. Bora submits that though a complaint has been filed by his client before the respondent number 2, alleging malpractice on the part of the respondent number 5 on 28/18 and a reminder on 19/6/19, no action has been taken on the said complaint. Anyway, my lord, eventually this honorable court says at page 119, in view of the submission made by the learned counsel for both parties, I dispose of the writ petition at the motion stage with a direction to respondent number 2 to examine the complaint made by the petitioner and dispose of the same by recent order. Now there passes an order, my lord, which your lordship will find in the next page. Please come to 120, my lord, at the last para.
Yes.
And whereas report of the circle officer, Sondrapur Revenue Circle, Kamrup Metro, clearly mentioned that villages, namely Panikhaiti and Kajali Suk, is situated in the river bank of river Brahmaputra within the jurisdiction of Kamrup Pragjudishpur Brahmaputra Fishery. The number 1 and 2 Upper Brahmaputra Fishery Society Panikhaiti is considered to be the nearest neighborhood cooperative society among the tenderers. So in fact, our favor, Miller. And whereas the matter to determine of nearest neighborhood certificate cooperative society of Kamrup Pragjudipur is settled with the report of the circle officer, Sondrapur Revenue Circle, the entire tender papers with comparative statement is sent to the Fishery Department, Government of Assam, white letter dated so for settlement of Kamrup Pragjudipur Fishery as they are the competent authority for settlement of the fishery. The neighborhood certificate submitted by number 11, part 5, that's the writ petitioner, in their tender bearing number so-and-so was examined and found that information provided to this certificate is incorrect, as none of the villages having operational area of the society is situated in the bank of Kamrup Pragjudishpur Brahmaputra Fisheries jurisdiction. Majority of the society's shareholders reside in the village Niz Govardhan, which is situated in the bank of river Kolong, 1 kilometer distance from Kamrup Pragjudishpur Brahmaputra Valley. But this order has attained finality. This order has not been challenged.
And which was the earlier order you have read?
Huh. That is at Milord, page number 65.
This order 65 was then, why this occasion for filing? No.
No, Milord, this is their original document. This annexure 6, page 65 is the certificate issued by the Assistant Registrar of Cooperative Societies. It clearly shows that it is in the neighborhood of number 25.
Page 96.
Yes.
This is what order.
1 second. No, 96 is the settlement order.
Settlement order.
Yes, Milord, which was challenged before the learned single judge.
This is the original order.
Yes, original settlement order, Milord.
And against which you preferred.
No, Milord. Even before this, once the tender was issued, when we got to know that the petitioner society is also participating, then we lodged a complaint with the authority that this is not in neighborhood. Therefore, please verify and determine. Since they were not doing anything, we approached this honorable court. This honorable court gave a direction that you dispose of their representation and the reminder, which they did on 23/9/2019.
23/9.
19. The one I read just now, Milord.
Yeah, the page number
Page 120.
120.
Yes. Which I read just now, Milord. It refers to that Guwahati High Court order, Milord. Second para. And whereas Honorable Guwahati High Court on hearing writ petition number passed direction on 19/7/19 to examine the complaint made by the petitioner Dijan Hazarika and dispose of the same by recent order.
This, what is the, what was the repetition of 8174/2019, a reference of this is made in page number 96.
Page 96, my lord, 1 second.
Okay,
Huh.
this was the settlement order, not
This was because what happened, my lord, the matter was not being, I mean, settled. So, my lord, this writ petition was filed seeking a direction for settlement. That is how
now, in pursuant to that, they have issued this.
settlement order.
And then against which you find a representation which was again not.
No,
decided.
not against this, my lord. We filed a representation against the eligibility of writ petitioner respondent number 10.
Fine.
Because we know that they're not in the neighborhood of this particular fishery. So we filed the representation. Since representation was not being disposed of, we filed the writ petition. And this honorable court directed the authority.
That you have, prior to that, you have filed this.
Yes,
19/7/2019.
yes,
The court has directed them to decide their objections.
yes, our objection
Yeah, they have decided by this speaking order
at page 120.
120.
Yes.
Then who preferred this writ petition number 8174/2000?
We preferred, my lord. That response challenging the, my lord, one part of the speaking order, not the findings, my lord. They say that fraudulently obtained, that part I have.
What they have said?
That, my lord, that speaking order, my lord, they, speaking order there, my lord, 23/9/2019, my lord.
Yeah.
That order we challenging in one part, my lord, because that finding of 1 kilometer, we agree, my lord. But so far is, my lord, they fraudulently obtained that word. Incorrect, my lord, incorrect. The word incorrect was there. Your lordship kindly see.
Where is that mentioned?
Yes. If your lordship would kindly come to me, lord, page number 121.
Yeah.
That where is
Last
the-
para. Neighborhood certificate submitted by number 11, part 2, Kolong Nodi Ansalik means by in their tender paper bearing so and so, was examined and found that the information provided in this certificate is incorrect.
Okay.
As none of the villages having operational area of the society is situated in the bank of Kamrup, Pragjudishpur, Brahmaputra fishery jurisdiction. This is the finding, my lord. Majority of the society shareholders reside in the village Niz Govardhan, which is situated in the bank of river Kolong, 1 kilometer distance from the Pragjudishpur. So according to this report, my lord, they do not reside in the neighborhood of this Kamrup, Pragjudishpur, Brahmaputra fishery. They reside in the jurisdiction of Kolong river Kolong, which is 1 kilometer from the
1 kilometer from Kamrup, this Brahmaputra fishery.
fishery, which is the fishery in question. So that, and more importantly, my lord, if your lordship would kindly come to page 120, the last para is very important. And whereas the report of the circle officer, Sondrapur Revenue Circle, by later dated so and so, clearly mentioned that villages, namely Panikheti and Kajoli Suk, is situated in the river bank of river Brahmaputra within the jurisdiction of Kamrup, Pragjudishpur, Brahmaputra fishery. The number 1 and 2 Brahmaputra Cooperative Society, that is the appellant, is considered to be the nearest neighborhood cooperative society among the tenderers. So this aspect was taken note of by the settling authority. And according to their certificate, my lord, which was issued by the Assistant Registrar of Cooperative Societies, which we have annexed at page 65, they are in the neighborhood of that deposits and fishery, not this Kamrup, Pragjudishpur, Brahmaputra fishery.
What happened to this petition 8175? No, sorry.
This is a common judgment, my lord. Improved judgment is common.
8174.
My lord, all that was said was that now the fishery should be settled. No, any finding has been recorded. Uh, 2007, 1 SCC 732. 2007, 1 SCC 732. My lord, on that failure of the petitioner to ever that they are in the neighborhood of the particular fishery, it is fatal, my lord. There is a direct judgment of the Supreme Court on this point.
But in fact, whatever the report suggests that they're 1 kilometer
Away.
in the same 1 kilometer away from this
No,
particular fish.
not only that, my lord, they are in the neighborhood of another fishery. They are in the neighborhood of Kolong River. Kolong. Not Brahmaputra Pragjyotispur fishery.
I agree. I agree.
Now, my lord will kindly have the judgment, my lord. They must assert that they are in neighborhood. If they do not assert, what is the consequence? My lord will kindly come, if the judgment is at page 732, my lord will kindly come to page 758, para 74.
Yes.
A jurisdictional fact is a fact which must exist before a court, tribunal, or authority assume jurisdiction over a particular matter.
Yes.
I may read it again, my lord.
Yes.
A jurisdictional fact is a fact which must exist before a court, tribunal, or an authority assume jurisdiction over a particular matter. A jurisdictional fact is one on existence or non-existence of which depends the jurisdiction of a court, a tribunal, or an authority. It is the fact upon which an administrative agency's power to act depends. If the jurisdictional fact does not exist, the court, authority, or officer cannot act. If a court or authority wrongly assumes existence of such fact, the order can be questioned by writ of certiorari. Now, my lord, in my humble submission, my lord, subject to what your lordship may say, this judgment has a vital bearing in the adjudication of issues for the simple reason, my lord, they at least in the affidavit in reply also they could have said that no, what they're stating is not correct. We are in the neighborhood of this particular. In any case, my lord, in the writ petition, there ought to be an assertion because your claim was rejected on the ground. Second ground was that you are not in neighborhood. In paragraph 5, you have stated so many things. There is no averment. So it has to be specific. So therefore, my lord, this is fatal. Now, my lord, on neighborhood, there are judgments of our High Court, my lord. I'll just place one. It would be 1998 1 ZLT 405. किमान बसर आए बताए? Yes, my lord. My lord, how to approach this towards this problem of neighborhood, my lord? It's a division bench judgment. In fact, 30 years back, I argued this case. And my appeal was allowed.
Paragraphs?
paragraph 20 and 22, 27, 20 and 27. Now, please come to 20. The learned judge, as rightly submitted by appellant's counsel, has approached the case from a wrong standpoint. It was not a case of exclusion from consideration, not even the case of the writ petitioner, nor it can be said by any stretch. The petitioner society's case was excluded from consideration, and bare reading of the impugned order would go to show that it was considered but not found fit for settlement of the fishery. It certainly cannot be a case of exclusion from consideration. So this was the perspective. Now please come to para 27. The question of neighborhood and area of operation has been subject matter of debate and discussion in several judgments. And even learned single judge has also made a reference to it towards the end of the judgment, indicating as to what it meant by neighborhood in the context of Rule 12. Without disputing the proposition, here again, the question that falls for consideration is one of the extent and scope of judicial review, whether this court, in exercise of its power under Article 226, examine the question of neighborhood with such minutest factual detail as to measure every inch of the distance at which a society is situated. It is something to be measured in foot and inches, all that this court extending the root jurisdiction. Such an extent would be nothing short of being violence to Article 226. All that the court can examine as to whether the conditions and requirement of neighborhood as prescribed under the rule, it was present to the mind of the settling authority. It is not expected that the writ court would be surveyor and measure the distance in meter and centimeter. If settling authority is alive to the requirement of the rules and same is reflected in the order of settlement of a fishery, writ court will not be justified and undertaking an exercise of measuring the distance between the two competent claims. After all, neighborhood is a relative term which is to be taken into account along with other conditions. It is not intent of the rule to treat neighborhood with geometrical actually attitude, not altitude, attitude and procedure. So my lord, the proposition which has been laid down in the judgment in my humble submission is, my lord, if the settling authority is alive to that consideration, while deciding whether or while deciding to settle a fishery, the settling authority must be alive to the requirement of neighborhood and should apply its mind and arrive at a decision. And normally that decision,
very little scope is.
very little scope. Now, in my humble submission, my lord, in the settlement order, read with that 23/9/19 order, there is a clear recital, and that order has not been set aside by this honorable, that has attained finality. So, my lord, there was nothing, no scope for the learned single judge to interfere, my lord, merely because he was a higher bidder. If, my lord, question of financial bid would come only when other things are equal. If other things are not equal, there cannot be any, my lord, grievance. Therefore, I think, my lord, the learned single judge at page 153 and 54 has committed an error in, my lord, deciding the issue in favor of the writ petitioner. And in any case, my lord, the jurisdictional facts were not pleaded. That's my humble submission.
Yes, Mr. Mehta.
My lord, your lordship kindly see, my lord, my learned friend knows very well exactly what happened in this case, my lord. I'll just, yes, I agree. I'm deciding in Livar Kalong. Near Livar Kalong, and he's deciding in Livar Brahmaputra. Although his secretary is not, my lord, far away from, he's staying in Guwahati, he's near High Court, my lord, Guwahati, Ujan Bazar, and that is not the matter. But my lord, the fact remains, my lord, your lordship kindly see, Livar Brahmaputra.
He belongs to that village.
My lord, yes.
Then if he resides in Guwahati, what's
No,
the
he is not belong to that village. Secretary is not belong to that village, my lord. He is staying here in Ujan Bazar, my lord.
He can have second house.
His
Yes.
native village was there.
No, no, my lord. Nothing village is not there, my lord.
No, then how he be?
Yes, my lord, his society, my lord, he is maintaining here, my lord. My lord, he knows everything, and I also know everything what is happening in this case.
Why you are this giving your personal information in this case?
My lord, no, I just giving I have even everything I have annexed, my lord. Even if space map, everything I have annexed. And the report which was, Now, my lord, I just giving a,
You may require to have the personal information of your client for many things.
my lord.
So
My lord-
this is one of the thing, whether what is, where he is
Your
residing,
lordship-
what his status is.
Your
Then you
lordship,
seek your material instructions. and-
my lord, I'm sorry, my lord. Your lordship, kindly, this is River Brahmaputra, as your lordship seen, my lord. That River Brahmaputra and my River Kolong falls under River Brahmaputra, and that junction, my lord, that fishery is situated.
Okay.
So he is nearer, very nearer, I am nearer. So it is
You
not
are
that,
admitting this.
no, yes, I admitting we are within the 1 kilometer distance, I agree. Yes, that is the finding of the, my lord, and that is taken into consideration, my lord. And now, my lord, your lordship kindly see the views of the fishery department, my lord. What is neighborhood and what is area operation, my lord? Up to 5 kilometer radius, my lord, it is, my lord, neighborhood and area.
Where is that?
Yeah, that is, my lord, I have annexed page 137. That is in the writ petition, my lord. Page 137.
Yes.
That is 137. Views of the government of Assam fishery department. Has a lawsuit body, page 137, my lord. Department settlement of authority under under Rule 12 of the Assam Fishery Rules 1953, as amended in regulations in the light of the comments to ensure. That is on to ensure. So straightway, your lordship, go to, my lord, page 138, second para.
Yes.
For determining the neighborhood issue is an intending bidder vice cooperative society, NGO, SCA, self-help group, government in view of the following program should be taken into consideration, and provided that members of the such bidder are inhabited in the village of area within 5 kilometer radius is the fishery. So neighborhood, my lord, what is neighborhood, my lord? That is defined. That is correct, my lord. He is near and he is very near, I am near, my lord. So now it is, if my lord, only the person who is staying in very near will always get the preference. Then, my lord, there is no question of, my lord, giving tender system, my lord. That's why, my lord, your lordship, in fact, my lord, Lanet Single judge very clear deal, my lord, and my case was also referred, my lord. Your lordship kindly see the judgment, my lord. In para 23, very clearly, my lord, stated. From record, my lord. Record was produced by Mr. D.K. Sharma, who is appearing on behalf of the, my lord, government. Para 23, page 151, my lord.
Yes.
Per contra, Sri D.K. Sharma Laner, additional senior government advocate Assam submitted the, my lord, para 23, my lord.
Yeah.
Okay. The per contra, Sri D.K. Sharma Laner, additional senior government advocate Assam submit that the impugned order contained regions and therefore no interference may be made. Sri Sharma has, however, candidly and fairly submitted that 100% actual fisherman certificate in favor of the petitioner number 1 issued by the concerned ARCS was available in the record. By referring to the record in original, the learned State Council has also made sterling reveals on that. As per the report of the circular officer, the recommendation of the settlement of fishery was actually in favor of the petitioner, which, however, has been ignored by the department. The same report has been marked as a flag X in the original record. So, my lord, everything was in my favor, in fact, but very wrongly, my lord, that was by the settlement authority not considered, my lord. So now, line on single judge, my lord, very clearly, my lord, all the issues, my lord, deal, my lord, that is passed, my lord, passed the impugned judgment, my lord, that is nothing to interfere, my lord.
That's all.
My lord, by way of reply, my lord, I'll just point out one thing. My learned friend has referred to that 5 kilometer thing, my lord. Kindly see the date, my lord. That was issued sometimes in 22 and settlement is of 2019. This is the view of the government subsequent, my lord. In fact, there was a direction by the Honorable High Court in on 6/9/22 in WPC number 8674/18. So thereafter it was done, my lord. So it was
Not prior to that.
not prior. So our settlement is of 2019. And secondly, my lord, there is a gazette notification, my lord, whereby now this is a, my lord, document which was issued by Now kindly come to serial number 3, my lord. What had happened, my lord, government of Assam found that there are a lot of, in fact, lordship had the occasion to deal with this notification in one case. Now kindly come to serial number 3. Experience certificate of Fishermen Cooperative Society assets or NGO is to be issued by DFDO, indicating that all members of the fishery have experience of fishing. In this case, it has been issued by the circle officer. That's one of the ground taken in the impugn order, my lord. Settlement orders. So, my lord, the learned single judge, in my humble submission, my lord, should not have made this roving inquiry, my lord. The scope of interference in the 226 matter, in my humble submission, is very limited. If the settling authority was alive to the requirement of the rules, then, my lord, normally lordships will not, it's not a question of, my lord, measuring in, my lord, the view that I am more, eminently suited. That report, which was obtained by me, pursuant to an order, that was never put to challenge. It was put to challenge, but it was not taken to logical level. So that order has attained finality. That is not under challenge. That's my humble submission.
Yes, Mr. Mayor. My lord, actually, regarding neighborhood, my lord, I have not mentioned, that is not correct. In para 4 of my petition, I clearly mentioned I am within the neighborhood, my lord. And my lord, also now, my lord, page 34, my lord, in para 33, para 4, I have stated that I am in the neighborhood. In that aspect, my lord, certificate is also there, my lord. And so far is now 100% still, if I have been, my lord, that first ground he has relinquished in before the land single judge, my lord. In fact, my lord, we are conscious of 100% fishermen. Now, this question arises by him, that's why I am submitting. And while arguing by the Mr. Bothakur before the learned single judge, he says that in first ground, my lord, there are two grounds, my lord, they have challenged, my lord. The one is neighborhood, another is actual fishermen. So actual fishermen part, page para 29, your lordship kindly say. Page para 25 of the judgment. Yeah. 25. Defending the action of the respondent, page 152. Defending the action of the respondent in rejected the bid of the petitioner and making the settlement in favor of the private respondent. As Bothakur learned counsel for the private respondent has submitted that since the record has revealed that 100% actual fisherman certificate in favor of the petitioner by the concerned ARCS was there, he would not join in issue of as far as argument regarding the first ground of rejection is concerned. However, the submit that a ground of neighborhood on the which he had been made it so that neighborhood he has been placed, my lord. My lord, that must
Order is that,
my lord.
Deep lord.
There was anything?
Yeah.
what is it?